Good evening. Happy Friday. We've got two documents to go over. I waited to cover the first one because I assumed, erroneously, that the second one would be a copy-paste, basically just simply stating that, we assert the same facts as and law as the other guy did, and so we joined in the motion. But that didn't happen. So here we are. So the first document this is Josh Abrams' opposition to Decastro's motion to dismiss Abrams' counterclaims. So, preliminary statement. I love preliminary statements. I don't actually love them. I think they're a waste of time. But now comes defendant Josh Abrams, who respectfully opposes plaintiff Jose Decastro's motion to dismiss Abrams' counterclaims. In his motion, Decastro levies a laundry list of reasons for dismissal. However, each such argument is either baseless or undeveloped in a way that it fails to adequately put Abrams and the court on notice of the reasons for dismissal. In all instances, Decastro's motion should be denied, which is an accurate statement, but it's fluff. I don't like them, but basically every other attorney out there does them. I tend to get cut more to the chase. And I haven't seen any real negative consequences from the courts yet for doing that. So I tend to think that courts aren't nearly as susceptible to a lot of the persuasion techniques that other attorneys use, and they're just looking for the meat and potatoes out of it. But whatever, that's just me. That's my personal bias, and your mileage and your attorney may vary. Procedural and factual background. On September 2nd, 2022, Decastro filed a lawsuit against Abrams and co-defendant Kate Peter. Peters is alleging defamation-based claims, including defamation and intentional infliction of emotional distress. These claims purport to be predicated on statements made by Abrams and Peter in various YouTube channels during an ongoing debate and argument between the parties. On November 7th, 2022, Abrams answered Decastro's complaint and counterclaims against Decastro for various defamatory statements Decastro made about Abrams on YouTube. This is Garrick's, by the way, and I think he normally does pretty good, except I'm seeing we have 9 pages, and I don't understand why we have 9 pages for this, but whatever. Also, before I bury the lead, I completely disagree with the route that he's choosing to take here, and I guess I'll explain at the end, but this is garbage. This is a waste of time. It's a beautifully written piece of garbage. It's well argued. He's correct on the law, as far as I can tell, but it's garbage, and it should be treated as such, in my humble opinion. And that's a false start there. Anyway, so 2 days later, Decastro docketed a letter with the court claiming he intended to dismiss his complaint without prejudice. And in each instance, citing to Federal Rule of Civil Procedure 41, recognized both Abrams and Peter had answered the complaint and filed counterclaims. The court could not dismiss the lawsuit without consent of all parties. Acknowledging the litigation was going to continue, Decastro has now moved to dismiss the counterclaims filed by both Abrams and Peter. With respect to Abrams, his counterclaims identified several defamatory statements Decastro made about Abrams. This is a correct statement of fact. This included statements accusing Abrams of being a rapist, an attempted rapist accusing Abrams of going to prison for raping his girlfriend and beating up his father. Abrams identified 4 YouTube videos that contained these defamatory statements. In addition, Abrams referenced other defamatory statements made on websites, chats, broadcasts, including those statements made through Decastro's YouTube channel, Delete Laws, and his backup channel called Chili's Backup. These defamatory statements were false. They were made with knowledge of its falsity or reckless disregard to its truth or falsity. They were made with actual malice, and they were designed to hold Abrams up to scorn, hatred, ridicule, or contempt in the minds of considerable and respectable segments of the community. I just want to point out that he is conceding, essentially, that Abrams is a public figure for the purposes of this. That is the knowledge of falsity or reckless disregard to the truth or falsity. That is the actual malice standard. Now, maybe they have something weird. Maybe they have something weird in Massachusetts that regards that they have a separate thing. So New York Times calls publishing something with knowledge of its falsity or reckless disregard of its truth or falsity, that is the actual malice standard. That's called actual malice. And you're going to say, well, that has nothing to do with malice. And I know it confuses everybody. And apparently it confused Garrick. because he said all of the elements of the actual malice standard, i.e. that the statements were made with knowledge of falsity or reckless disregard to its truth or falsity, and then he goes on to say they were made with actual malice. And okay, bro. Like, now it's not going to hurt him, but it just makes me think that, I don't know. It raises questions. That's all I'm saying. It raises questions. Questions have been raised. And, you know, if all of my pleadings were subjected to the same level of scrutiny that Garrick's pleadings have been subject to, you know, I'm sure that people would find things to nitpick on my pleadings too. So I'm not trying to say too much there. It's not fatal, but it's weird. Abrams filed a one-count counterclaim for defamation given the financial damages, emotional distress, and anguish suffered as a result of Decastro's statements. Now, this is why I think it's stupid. Number one, Abrams isn't going to be able to prove any real damages. To the best of my knowledge, he's not getting psychological help. You know, he's not seeing a therapist over this, building up those damages, because you need receipts. Like, you need actual receipts. You need special damages to start getting all these general damages. And really, realistically speaking, you need special damages to get general damages. That's the realistic thing about it. If you walk up to a jury and you say, I want all these, you know, I want $250,000, and they're going to say, for what? You're going to say, well, pain and suffering. Okay. Like, what pain? What suffering? How do we know how much pain and suffering you have? Oh, well, that's pretty easy to do. You show the specials. You show the receipts. I had to go to the therapist once a week, every week for an hour a day, and I had to tell him all my innermost thoughts and feelings, and it's just been a horrible emotional roller coaster and then they're going to be like, oh, well, that's terrible. How much did that cost you? Oh, that cost me $10,000. They're going to be like, okay, so that must really suck. You must have really gone through a lot to have to spend $10,000 on a therapist. And then you're like, yeah, and I want $250,000 for my pain and suffering. And they're going to be like, well, you spent $10,000 talking to someone about all this stuff. There must be pain and suffering that goes along with it. So we're going to give you like $100,000 or whatever for it. You know, they're going to come up with some number, but you have to have those general damages. Like with a car accident, if you get injured, personal injury, and you say, you know, I've had pain and suffering from my car accident, and the jury's going to say, oh, well, that's pretty cool. Did you go to the doctor? You're going to say, well, no. Did you go to the chiropractor? No. Did you get physical therapy? No. Well, then how much pain and suffering could you really have been in? You know what I mean? That's what he needs to do. He needs to build that up. As far as I know, he hasn't done it yet. As far as the financial damages, loss of income to his YouTube channel, he's going to have to prove that. And he's going to have to prove that it's related to this defamation, that this loss of character, this loss of respect from the community has somehow damaged him. But in addition, he's also going to have to show that he had something to lose. And to the best of my knowledge, he is a convicted felon. So did it really change anything for Chile to make these statements? So this is a loser of a counterclaim. That's just out of the gate. It's a loser. And then collecting it is going to be another loser. Chile is, once again, judgment proof. You're not going to get any money out of him. Getting a piece of paper that says Chile owes you $1 million, it's still just a piece of paper. And its only value is as a piece of paper. You're not going to collect any money out of Chile. That's just a thing. That's just going to happen. I don't know. You would spend so much money, so much time and money trying to collect that money out of Chile that it's just not worth it. The amount of money you get back is not going to be worth the amount of time you put in. How do I know this? Because I've done collections before. Like, as an attorney trying to collect judgments, you know, people will pay me to try to collect judgments. And eventually, you know, you get some money out of something. Like, every time you put a wage garnishment on their job, you know, money starts coming in. They realize there's a wage garnishment. They quit and they find another job. It's just too expensive to do on some of these deadbeat people who don't have any assets. So not only is this a loser, and as far as you're not going to really have a lot of damages, but what damages you do have, you're not going to be able to collect. So the question that you should always ask yourself is, would my attorney take this on a contingency basis? That's always the question that you want to ask yourself. If your attorney is not willing to take it on a contingency basis, then it's not worth your time either. Because you got to remember, the attorney's thinking, number one, is there liability? Number two, are there damages? And number three, can I collect those damages? And if any one of those errors out, then he's going to be like, yeah, I'll do it, but you got to pay me hourly. And for those of you who are saying, well, he already hired this attorney to defend him. Well, attorneys can do a thing where the attorney is going to have two bills, generally speaking. At least that's the way I've done it in every office I've ever worked in. You have the defense, and that's hourly. But then you have the counterclaim, and that you would bill on a contingency basis or on hybrid basis, a reduced rate against a percentage of the return, or hourly. But they're two separate billing events. If you're working on the defense, you're billing on this timesheet. If you're working on the counterclaim, you're billing on this timesheet. So it can be done. Anyway, that's a long diversion. So anyway, the only thing that Abrams is going to get out of this is a bigger attorney bill at the end of the month. I mean, I know some people who are going to be like really childish. They're going to be like, ha, he's overcome Chili's motion to dismiss his counterclaim, and ha, Chili, you suck. But it's a meaningless victory. It's hollow. Abrams has not actually improved his position as a result of this. It's useless, but whatever. That's just my opinion. I'm just a first-year family law attorney. What do I know? Other attorneys would probably tell you otherwise. On November 16th, 2022, after Abrams filed his counterclaims, Decastro amended his complaint to raise allegations of copyright infringement based on Abrams' alleged unauthorized use of Decastro's YouTube videos on his own channels. The sole count of the first amended complaint is a claim for copyright infringement pursuant to federal statute. Then it says, there's a footnote, Decastro then filed a supplemental complaint to add YouTube as a defendant. I would not give up that ground. I would not say that. I would say that Decastro filed a second amended complaint because that's what the court called it. And I would not second guess the court. I think it's weird. I think it's weird that he concedes this. I think it's stupid that he concedes this. I would say Decastro then filed a second amended complaint replacing Abrams and Peter with YouTube as a defendant. And I would hold that position. The court called it a second amended complaint. By God and by freaking golly, I'm going to call it, as the defense attorney, I'm going to call it a second amended complaint. Let Chili figure it out that it's not. Let Chili make the argument that it's not. Because if he can't, then I'm off to the races. See ya, wouldn't want to be ya. I don't understand why we gave up this ground. And then the second footnote, it appears that Decastro, in amending his complaint, has abandoned the defamation-based causes of action in favor of his newly minted copyright infringement claims. And, Abrams is worried that Decastro has done this intentionally, so they can do an end run around this court's orders declining to accept his belatedly filed notice of voluntary dismissal of the defamation-based claims. Abrams' concern is that Decastro may refile the defamation cause of action in a California court, a venue that lacks personal jurisdiction over Abrams, a Massachusetts resident with insufficient ties to California. Well, there's so many ways to defeat that. Number one, if he files in a state court, you can remove, or you can number one, challenge it on personal jurisdiction. That's that special appearance. You don't have to file an answer. You just especially appear to challenge jurisdiction. And then if you lose on that, then you file to remove it to federal court. Once you get into federal court, there's that 41D that says basically if someone dismisses a claim in one court and refiles it in another court, then you can essentially hold them for ransom for the court costs. And until they pay the court costs, then that action is stayed. And then he would actually have to pull money out of his pocket and hand it to you to proceed. He's not going to do that. It's done at that point. Well, let's just pretend that he's smart enough to figure out how to get past that. I don't think he is. I don't think he has a very good argument because it is apparent what he's doing. He's literally said he's doing it. So obviously it's super easy. But let's just pretend that he does get past that point. Then you hit him 12b-6. It's called claim splitting. California doesn't recognize it, but the federal court does. So you have not one, not two, but you have 3 chances to get this sucker killed if it goes to California. But, I'm cynical. I'm super cynical. Garrick doesn't get paid if it goes to California. And there's a problem. There's your rub. The California court should nonetheless dismiss such a refiled claim, not only for lack of personal jurisdiction, but under the doctrine against claim splitting, which California doesn't recognize. It'd have to be the federal court, so whatever, which precludes a litigant from strategically pursuing in a subsequent suit claims which were or could have been brought against the original defendant in the original suit. I kind of think that Chile was going to file it in a California court, in an actual California state court. That was my understanding. But if he is going to file it in federal court, then yeah, you'd go for you'd file a motion to dismiss for failure to. Well, I'd go for failure for personal jurisdiction. I would do the claim splitting. I think that's a 12b6 for claim splitting. I could be wrong on that. It might have its own name. And then, barring those two, once those two fail, then I would try the 41D motion for the bad faith refiling in a different venue, and then 12b6 based on any other grounds that I could think of if he was amending his complaint to get past it. Yada yada. So yeah, he's anticipating that it would be filed in federal court, and it could be removed to federal court, unless of course the jurisdictional amount is below what $75,000. Anyway, so while such a subsequently filed claim would be promptly dismissed, Abrams recognizes that Decastro has brazenly admitted that his goals in pursuing litigation against Abrams and Peter is not to win but to vex. Yeah. I'll break them financially. They will. I mean, we've been through all these allegations before. The court is very aware of it. This is just a waste of paper at this point. Such improper and ulterior motives warrants this court's attention here to avoid future abuse and harassment. Accordingly, Abrams will agree to give Decastro one final chance to plead the defamation cause of action in a third amended complaint with Abrams' assent, so long as it is requested within 10 days of receiving Abrams' forthcoming motion to dismiss the second amended complaint. Oh, so, well, good. Abrams is going to file a motion to dismiss the second amended complaint. At least, I'm assuming just his 12b6, any allegations against him. So interesting. So that's good. Should Decastro decline the information, Abrams asks this court ruled that the defamation-based claims raised in the original complaint are dismissed with prejudice and reject any further attempts by Decastro to amend the complaint as futile, unduly prejudicial, and in bad faith, and in furtherance of Decastro's documented dilatory motives. So all of this should just be in the forthcoming 12b6. So there you go. On December 8th, 2022, Decastro moved to dismiss Abrams' counterclaims, yada yada. Although the arguments are undeveloped, he seems to merely state a list of 12b defenses, including dismissal pursuant to Federal Rule of Procedure 12b1, lack of subject matter jurisdiction, 12b2, lack of personal jurisdiction, 12b4, insufficient process, and 12b6, failure to state a colorable claim for relief. Each of these bases for dismissal can be disposed of in short order, as none of which are remotely meritorious. Accordingly, Decastro's motion should be denied. Now, I think the only way it can be done for Decastro is if the court finds that, if the court believes that the $75,000 jurisdictional amount of Josh's counterclaim isn't met. If the court believes, like, I don't think that that's good faith. I think it's $35,000 or $25,000 or $10,000 or $15,000 or whatever, and then kicks it as a it's not a mandatory counterclaim. The court has permissive jurisdiction over it, not mandatory jurisdiction over it. So the court doesn't have to keep it. So that's the only way. And if the court denies, my dog just farted. He just came over here and farted. He loves me. If the court denies Chile's motion to dismiss, then the court would be left. So here's the problem. The court, assuming that Abrams wins on both motions, number one, to dismiss the second amended complaint with prejudice, can't be refiled. But number two, keep that counterclaim. The court's going to end up in this weird position where Chile has no cause of action against Abrams, and Abrams has a cause of action against Chile. And that's just so weird. I don't think the court would want that. So I don't think the court's going to appreciate the way he's pleading this. I think he should have smashed the two together, essentially giving the court two alternatives. one, either the counterclaim stays and the motion to dismiss is not granted, or the motion to dismiss is granted and the counterclaim is also dismissed. So the whole thing goes away. In for a penny, in for a pound. I would have given the court that option, but that's just me. Well, I wouldn't have filed this anyway. I'd have just gone to 12b6. That'd have been like peace. So the court has original subject matter jurisdiction over the counterclaims. Decastro's first basis for dismissal should be denied out of hand, as the court clearly has subject matter jurisdiction over Abrams' counterclaims. The court has jurisdiction to hear state law claims where the parties are diverse, the amount of controversy exceeds $75,000. Abrams and Peter are both citizens of Massachusetts. Decastro is a citizen of California, and the amount in controversy exceeds $75,000. That is his allegation. Again, the court doesn't have to necessarily take that as true. The court can kick it out. Just because you say $75,000 doesn't mean the court has to believe $75,000. Indeed, given the nature of the defamation-based counterclaim, seeking actual damages for loss of revenues due to declining YouTube viewership and membership, as well as emotional distress and mental anguish arising out of Decastro's repeated defamatory comments about rape and domestic violence, pleading damages in excess of $75,000 is certainly plausible and made in good faith. Certainly is essentially taking the place of clearly there. It could also be patently. So, I mean, it's just a dumb use of the words. Don't like it. Under these circumstances, the amount of controversy pled in the counterclaim controls. See this particular case, the amount specified by the plaintiff controls as long as that amount is concerned in good faith. A court can dismiss an action for insufficiency of the counterclaim or of the amount of controversy only when, from the face of the pleading, it is apparent to a legal certainty that plaintiff was never entitled to recover some equal to or in excess of the jurisdictional minimum. Accordingly, the court has subject matter jurisdiction over Abrams' counterclaims. I'm going to press X to doubt. The court has probably seen its fair share of defamation causes of action and can make an educated guess based on the pleadings about whether or not the jurisdictional minimums are pled in good faith. Decastro's motion does not seem to address whether the court has subject matter jurisdiction under the diversity of citizenship statute and instead focuses on supplemental jurisdiction. However, the court need not address supplemental jurisdiction if, as here, the counterclaims have original jurisdiction under 28 U.S.C. 1332 in the first instance. For that reason, the motion should be denied. Even if the court determined the original jurisdiction was lacking under Section 1332, the court would still have supplemental jurisdiction to hear Abrams' counterclaims under 28 U.S.C. 1367A. The counterclaims are so related to claims in the action within its original jurisdiction. Courts have interpreted this "so related to" language to encompass claims that share a common nucleus of operative fact within the claims over which there is jurisdiction, or are such that they would ordinarily be tried in one judicial proceedings. In this case, both parties allege various statements made in ongoing back and forth debates and arguments over YouTube channels were defamatory. It is a common nucleus of facts that makes the claims and counterclaims related. To get around this, Decastro seemingly asks this court to invoke its discretion to decline supplemental jurisdiction pursuant to 28 U.S.C. 1367 C2 because the state law claims, according to him, purportedly dominate over the original federal claims. This argument is undeveloped as it does not put Abrams or the court on notice as to how Decastro believes this to be true. Decastro fails to recognize his state law defamation claims where he invoked subject matter jurisdiction are no different than Abrams' state law defamation claims. Accordingly, it is hard to take Decastro's claim of predominance seriously when the claims were essentially the same, but this inquiry is irrelevant because the court has original jurisdiction under 1332 and the court cannot decline jurisdiction under 1367C. I think the court can decline. By amending the complaint and abandoning the defamation cause of action in favor of a copyright infringement cause of action, that would have the effect of changing the court's original basis for jurisdiction from diversity jurisdiction to federal question jurisdiction. This does not affect the analysis, so whether the court has subject matter jurisdiction over Abrams' counterclaims. These counterclaims still have the original diversity jurisdiction for the reasons stated above, and Decastro has failed to articulate any sound argument as to why diversity jurisdiction is lacking, why supplemental jurisdiction is lacking, or why the court should decline to exercise supplemental jurisdiction, given the claims raised in either the first or second amended complaint. Next section. The court has personal jurisdiction over Decastro. That's obvious. He's a plaintiff. He filed there. Decastro next seeks dismissal for lack of personal jurisdiction. The court can make quick work of this because a plaintiff consents to the personal jurisdiction of a court by bringing suit in that court. Period. End of story. Quaderat demonstratum. Then he says there's no insufficiency of process. Decastro also seeks dismissal under the seldom evoked 12b4 defense, claiming insufficient process. The defense challenges the contents of the summons. It's stupid. This is dumb. The defense fails because, as a counterclaim, there were no summons and there was no service of process. Instead, service of Abrams' counterclaims was completed by sending it to a registered user by filing it with the court's electronic filing system. Now, unless I'm wrong, 12b4. Yeah. Am I not in 12? Yeah, I'm in 12. Yeah, so he's missing. So process is the summons. It's not the service of the summons, it's the summons itself. So if you received the summons without a copy of the complaint, that's insufficient process. You only got half of it. If you got the complaint without the summons, that's insufficient process. You only got half of it. If there was some sort of a defect on the summons itself, like if it didn't say your name on the summons or something like that, that would be insufficient process. Insufficient service of process is different, which... See, even here he jumps to he even recognizes it's wait, he's talking about service. He's talking about service of process. Ah! Oh Jesus fucking Christ! God, that is shitty. That's Garrick, sir, Garrick, sir. How dare you, sir? How dare you? How dare you confuse process with service of process? Oh. And he's arguing service. Decastro made local, this is a footnote, Decastro made a reference to local rule 40.1, claiming a failure to identify a related case. Yeah, that's stupid. This rule places an obligation on the plaintiff filing initial pleading, not defendant filing counterclaim. So if the defendant is aware of another case that is tied to the same thing, when the defendant files a counterclaim, the defendant has an obligation, I believe, under local rule. But Decastro would have had to do it. But filing a counterclaim into the same case, you don't have to notify the court of the original case. You're literally filing into that original case. I mean, it's stupid. I don't understand this, but yeah, the court is aware that you're filing a counterclaim into a case. You don't have to notify the court that that case exists that you're filing a counterclaim into. Massachusetts defamation law applies. That is correct. Well, against Abrams and Peter, it applies for the defamation of them by Decastro, but California applies for the defamation of Decastro by Peter and Abrams because it Cosby. Finally, Decastro challenges the merits of Abrams' counterclaims on a simple point. Decastro claims the counterclaims do not articulate which state law applies. Doesn't have to. Decastro cites no case law that stands for the proposition that the claimant must identify the substantive state law that the court should apply at the motion to dismiss stage. That's one thing that Mark Stout doesn't understand. There's a difference between a legal conclusion and a fact, an allegation of fact. And your complaint has to contain allegations of fact and not necessarily legal conclusions. So one of the legal conclusions that Stout likes to talk about is the legal conclusion that a specific government building is a limited public forum. But the court doesn't care what you think it is. The court's going to make its own determination. So the court's going to look at the facts that you allege, like it's a city hall. and these are the things that you do in the city hall, and there's these kind of policies, and it's been used in this kind of way. And those are the things that the court's going to look at. Those are facts. Whether or not it is a limited public forum is a conclusion of law. And what state law you apply in this particular case is a conclusion of law. The judge is going to make that decision based on the facts. What are the facts the judge is going to use? What state is the plaintiff in? The plaintiff in California will use California against the claims that he's making about defamation. What state are the cross-complainants, counter-complainants in? Massachusetts. Well, then we'll use Massachusetts state law to determine whether or not they've been defamed. That's what the judge does based on the facts of where the defamed persons are. Nevertheless, the answer to Decastro's question is readily apparent. Where a statement was published nationally, the law of the state where the defamed party was domiciled at the time of publication prevails or applies. See Green versus Cosby. I guess Garrick has been watching my videos because I said that already. And I have videos on it if you doubt me. Given this well-settled principle, it's quite evident from the text of the counterclaims that Massachusetts law applies. It does against Abrams and Peter. It does not against Chile. It does for Abrams and Peter. It does not for Chile. Abrams pled that he was a resident of Massachusetts. That's a fact. And the defamatory statements were published on YouTube channels. That's a fact. These facts give the necessary inference that Massachusetts defamation law applies. Perfect. Decastro does not articulate any other basis for dismissal pursuant to Federal Rule of Civil Procedure 12b-6 other than baldly making undeveloped arguments about an alleged failure to identify the requisite elements of a viable defamation case under Massachusetts law. I don't believe so. Federal law is notice pleading. And so it doesn't really matter what the state pleading rules are. If the state pleading, like California is we're a fact pleading state. So you have to plead all the facts that would, that if true, would meet all the elements of defamation in order for your complaint not to be demurred. In the federal courts, you have to basically put someone on notice what you're suing them over. And that's much easier to do. You don't have to state all of the elements. You don't have to state facts that, if true, would satisfy all the elements, I should say. You can make much broader statements like, he defamed me by calling me a piece of poop. And it cost, there's more than $75,000 in damages. And that's it. That's really, it's that simple. You might not survive a motion to dismiss with those few facts, but that's really it's basically all you need. It's very little, at least compared to what California is. So Abrams declines to guess what specific issues Decastro has with the defamation cause of action, and this court need not consider such undeveloped arguments. And yes. In any event, Massachusetts law simply requires the following elements to be pled in the defamation cause of action. But federal rules of civil procedure apply. Federal rules of civil procedure apply. Federal rules of civil procedure determine what needs to be in the complaint. It is notice-based pleading, and it doesn't matter. It doesn't matter what Massachusetts law is. Why are we talking about it? I don't know. But apparently, in any event, Massachusetts law simply requires the following elements to be pled in a defamation cause of action. Why? False statement of and concerning Abrams. 2, the statement could damage Abrams' reputation in the community. 3, Decastro was at fault in making the statement. And 4, the statement causes economic harm or is actionable without proof of economic loss. And he's citing cases that are citing Massachusetts cases. I am pretty sure that those are the things you have to prove in order to prevail in a defamation cause of action under Massachusetts law, but I don't believe you have to plead those. Here, Abrams cited several statements that Decastro made, accusing him of being a rapist or engaged in domestic violence. Those statements were false, yet published by Decastro nonetheless. Given the atrocity of the false statements made by Decastro, the defamatory statements were designed to cause and have caused damage to Abrams' reputation. Finally, Abrams pled that he was financially harmed through a loss of membership and viewership of his YouTube channel, as well as emotional distress and anguish. While unclear what issues Decastro has with Abrams' counterclaims, other than Decastro's failure to recognize that this as a claim that applies Massachusetts defamation law. That this is a claim, sure. It is clear that Abrams has sufficiently pled each element of a defamation cause of action, and the motion should be denied. Conclusion: the defamation cause of action Abrams filed against Decastro is a viable counterclaim, and none of the defenses raised by Decastro justify dismissal. Decastro's motion to dismiss Abrams' counterclaims should accordingly be denied, and it should be denied, and it probably will be denied, and then Garrick will continue to make money on it. So that's awesome. Then, in a completely different filing, we have Kate Peters' motion to dismiss the First Amended and supplemental complaints, Memorandum Incorporated. Now, I read this. I have not read this. I didn't read the other one ahead of reading it. So, there you go. But I'm just going to go ahead and say, again, Wish gives up the high ground. He's calling the supplemental complaint a supplemental complaint. The court, Discord. Oh, wait, actually I have it here. I can do it this way. Yes, thank you. The court called it, hold on. Quit moving my hand. I'm not petting you. I'm not petting you right now. Don't try to be cute with me. Stop. Yes, okay, fine. You win. All right, one-handed typing. Let's see. We want second. Here we go. Second amended complaint. They call it a second amended complaint. Motion for extension of time after the second amended complaint is filed to answer. So this is the order. So the judge granted second amended complaint. Here we go. It's in order. Plaintiff's motion. So she calls Chili. It's his motion to file a second amended complaint. And defendant filed a motion for time to answer the forthcoming second amended complaint. It's a second amended complaint. The judge said it. It's in both defendants' best interest for it to be a second amended complaint. Like, I don't understand. Are you trying to convince the judge that it's a supplemental complaint? Is that your angle? You're like, hey, you know what? I really want to make this as hard on myself as I possibly can. You know what would be best? What would make this absolutely hardest would be if I conceded that it was a supplemental complaint. And I didn't say, no, this is a second amendment complaint. I would be just the dumbest thing I could possibly do. So let's do it. Because why wouldn't you? Hi, yes, welcome back. Thank you. You did hear me. All right, so this is Kate Peters' motion to dismiss First Amendment supplemental complaints, Memorandum Incorporated. Defendant and plaintiff in counterclaim, Kate Peter, hereby moves this court to dismiss First Amendment complaint and supplemental complaint of plaintiff and defendant in counterclaims of Jose Maria Decastro, collectively the complaint in their entirety. Following the filing of the First Amendment complaint, Mr. Castro filed a supplemental complaint with leave of the court. However, the supplemental complaint does not contain any counts. Ms. Peter understands that Mr. Decastro is still pursuing. Ms. Peter understands that Mr. Decastro is still pursuing the counts set out in the First Amendment complaint. And so, for the purposes of this complaint, is treating the First Amendment complaint and supplemental complaint together as a cooperative complaint in this action. Ms. Peter concedes the worst possible position for herself out of the gate. Because why wouldn't you? Why wouldn't you do that? While the complaint alleges that Miss Peter and others publish content to YouTube that largely only copies my content for monetary gain in the same YouTube content market and without my consent, a review of the at-issue videos reveals that they each reside comfortably within the borders of the fair use exception to the Copyright Act. In other words, the very videos upon which Mr. Decastro relies require dismissal of the complaint. Factual background number 2. Solely for the purposes of this motion, Ms. Peter accepts the allegations of the complaint as they are pled. That's fine. That is fine. That's fine. I have no problem with that, because you have to. The allegations of the complaint are straightforward. Mr. Decastro alleges that Ms. Peter and others have stolen Mr. Decastro's content on YouTube regarding constitutional law, or the misunderstanding thereof, and Mr. Decastro's attempt to tear down some of the racist laws in the country to profit off of that content. He contends that Ms. Peter has done so in order to avoid having to create the content themselves. According to Mr. Decastro, Ms. Peter and others make money from copying my content onto their YouTube channels, which are the same market as Mr. Decastro's content. Why are we repeating? She has. The judge has the First Amendment complaint. You don't have to repeat all this crap. We accept the allegations made in the First Amendment complaint as true. Period. End of sentence. Move on. But I guess we need to put all the ones that we think are the best. I like to pad my emotions. Mr. Decastro makes no allegations regarding the purported effect of Ms. Peter's copying of his content upon the potential market for Mr. Decastro's content. On the basis of these allegations, Mr. Decastro brings a single count for copyright infringement against Ms. Peter and others. Mr. Decastro includes in his complaint all the links containing his YouTube content and contends that Ms. Peter and others publish content to YouTube that largely only copies my content for monetary gain in the same YouTube content market and without my consent. See Exhibit 1. I assume it's going to be in here. If not, whatever. Mr. Decastro does not, however, identify any of Ms. Peter's content upon which he relies to contend that Ms. Peter and others have stolen his content. A review of the videos in which Ms. Peter has discussed Mr. Decastro, and then this is, while the materials not attached to the complaint are ordinarily excluded from consideration on a motion to dismiss, they may be consulted if their authenticity is not disputed by the parties and they are central to the plaintiff's claim, or they are sufficiently related to in the complaint. Ms. Peter's videos upon which Mr. Decastro relies are exactly such materials as they are central to Mr. Castro's claim and are sufficiently referred to in the complaint. Review of videos in which Ms. Peter has discussed Mr. Decastro reveals that in the number of videos which Ms. Peter has produced regarding Mr. Decastro, she's only glancingly referred to his content regarding constitutional law and alleged attempts to, quote, tear down some of the racist laws in the country. I wonder how many hours he spent reviewing Kate Peters' videos so that he could bill her for this travesty right here. Ms. Peters' content regarding Mr. Decastro relates almost exclusively to Mr. Castro's litigations, his alleged attempt to practice law, and his attacks on individuals. Number 4, okay? Number 4 are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 plus 9 is 19 videos. 19 videos. When Ms. Peter does use Mr. Decastro's content in her videos, she highly edits Mr. Decastro's content to present it in a satirical and often critical manner. For example, in the video Chillism Number 1, How to Control Your Temper, link at 2 seconds. Glad you shaved 2 seconds off it there, buddy. Thanks for starting us off 2 seconds into the video. That was helpful. Such videos use brief, spliced clips of Mr. Decastro with effects that Ms. Peter adds in editing. In other videos, Ms. Peter and others comment on and discuss Mr. Decastro's content discussing this case or other litigations. See this other video. On the rare occasions when Ms. Peter has made videos addressing Mr. Decastro's discussion of the law, apart from his own litigations and posted clips of Mr. Decastro's content, she has done so in order to criticize and critique Mr. Decastro. See this one. I got a hair in my nose from petting a dumb dog. Or it's cocaine. One of the two. Ms. Peter's content regarding Mr. Decastro, to the limited extent she has ever referred to his content about the law at all, constitutes criticism, critique, and commentary, excluded from the protections of the Copyright Act by the Fair Use Doctrine. No viewer of Ms. Peters' videos should ever conclude that she was or is seeking to pawn off Mr. Decastro's legal analysis in order to turn a profit. The Fair Use Doctrine is a safe haven from copyright infringement. It creates a privilege for others to use copyrighted material in a reasonable manner, despite the lack of the owner's consent. The Copyright Act itself, as Section 107 establishes the Fair Use Doctrine, which may be found when copyright work is used for criticism, comment, news reporting, teaching, scholarship, or research. The four fair use factors are: number 1, the purpose and character of the use; number 2, the nature of the copyrighted work; number 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole; and number 4, the effect of the use on the potential market for or value of the copyrighted work. A court can make determinations as to fair use before trial where the parties dispute only the ultimate conclusions to be drawn from the admitted facts. That is the situation here. The videos at issue say what they say. The videos say what they say. Well, thank you, Mr. Lawyer, for pointing out that the videos say what they say. I'm sure the court never would have drawn that conclusion had you not pointed it out to her. You, sir, are a master of your craft. Indeed, a motion to dismiss is appropriate where the at-issue facts are derived from the complaint or the limited additional materials for a motion to dismiss purposes. Ms. Peters' videos amply satisfy the first factor, as to which the courts find that the purpose and character of the use tends towards fair use, where the new work adds something new, with a further purpose or different character, altering the first with new expression, meaning, or message. Subsiding things. A review of Ms. Peters' videos reflects that she substantially edited, condensed, and synthesized Mr. Decastro's work. Substantially. Clearly. Though the complaint does not provide sufficient allegations to characterize the nature of the copyrighted work, the second factor, Ms. Peters' videos regarding Mr. Decastro, reflect that her focus was almost exclusively upon content other than legal commentary. In other words, the content upon which Ms. Peters did comment was not, quote, creative, end quote, but rather related to Mr. Decastro's actions and invective. The complaint does not make any allegations about the third factor, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Nevertheless, a review of Ms. Peters' videos reveals that this factor augurs in her favor as well. It augurs, and that's a lovely use of the word. She at most uses a vanishingly small fraction of Mr. Decastro's commentary on the law. That's a quantifiable amount, vanishingly small fraction. That the third factor tends against the finding of fair use when a party copies the most interesting and moving parts of a work, or when more of the original is copied than necessary. Ms. Peters neither copied the most interesting parts of Mr. Decastro's content, nor used more than necessary. She copied the least interesting parts. That's why she chose them, because they were the least interesting. As to the fourth factor, effect on the market, the complaint says exactly nothing about the impact upon Mr. Decastro's market. Under that factor, courts consider both, number 1, the degree of market harm caused by the alleged infringer's action, and number 2, whether unrestricted and widespread conduct of the sort engaged in by the defendant would result in a substantially adverse impact on the potential market for the original. Here, the complaint is devoid of allegations regarding the purported impact on the market. In particular, the complaint does not allege, because it cannot, that Ms. Peters has usurped the market for Mr. Decastro's work, because the infringer's target audience and the nature of the infringing content is the same as the original. A review of Ms. Peters' videos make it clear that her audience is distinct from Mr. Decastro's. Ms. Peters criticizes Mr. Decastro. She says she does not seek to appeal to his audience. At bottom, Ms. Peters' videos regarding Mr. Decastro are exactly the species of content which is protected under the fair use carve-out. From the face of the complaint and the videos referenced therein, there is no basis to conclude that Ms. Peters' videos fall outside the ambit of the fair use doctrine. For the above stated reasons, Ms. Peters submits that this court should dismiss the complaint in its entirety. No mention at all that none of the copyrighted works were registered. Nope, no mention of it. No mention of it. Sick. Well, anyway, so that's awesome. That's awesome. I guess I'm the dumb one. I probably am the dumb one. They've been practicing law longer than me. They probably know more than I do. I would not have conceded the Second Amendment complaint, supplemental complaint issue. But anyway, that's just me. So we'll see how it shakes out. I think the court can actually look at the court can make a lot of decisions. The court can say, I said the Second Amendment complaint was a Second Amendment complaint, and I'm going to dismiss it. The court can do that. The court can say, you didn't register any of these. I'm going to dismiss it. The court can do that. So the court can do lots of things. So we'll see how it shakes out. Anyway, I'm fairly disappointed in both of them, but who really cares? Who cares what I think? I'm just a first-year family law attorney. Thanks for watching, and have a great day.